The bailiff called the case the way people read numbers at a deli counter. Flat, practiced, already moving on. I stood when he said my name, not because I felt small, but because the room wanted me to. Across the aisle, my mother-in-law rose a half-second earlier, like she was racing me to the moment. She wore a pale wool coat that probably cost more than my car, pressed just enough to say she'd planned this. Her hair was smooth, her face was dry, the kind of grief that photographs well. This wasn't a hearing. It felt like an execution scheduled between lunch and the judge's next docket. My name is Imani Brooks, and I never imagined I'd have to defend my children's future in a courtroom against my own mother-in-law. She believed money and blood gave her power over my life. What she didn't know was that my husband planned for this moment. Stay with me, because the truth doesn't shout, it waits. Tell me where you're watching from, and hit subscribe so you don't miss what happens next. Behind her, my husband's family filled the first two rows. His cousins, an aunt who hadn't called in years, an uncle who once told me I was lucky to marry into their name. They sat shoulder to shoulder, straight-backed, eyes forward, like a panel waiting to decide whether I deserved to exist in their world without my husband standing beside me. My children weren't there. I made sure of that. I wasn't going to let this room touch them. The judge adjusted his glasses and glanced down at the file like it was already familiar. That alone told me everything. Papers had been filed. Conversations had happened without me. Someone had decided urgency mattered more than fairness. "Ms. Brooks," he said, looking up, "this is a petition for emergency authority over the estate. Do you object?" My mother-in-law's lips tightened into something close to a smile. Not joy, anticipation. I inhaled once. Not deep, not dramatic, just enough to keep my voice steady. "Yes," I said, "I object." Her attorney stood immediately like he'd been waiting for the cue. Dark suit, quiet tie, a watch that didn't flash but still wanted to be noticed. He didn't look at me when he spoke. He addressed the judge like I wasn't there. "Your Honor," he said, "the petitioner is requesting immediate authority to protect assets that are currently unmanaged. The respondent is recently widowed, emotionally compromised, and inexperienced in financial matters. This is about stability." Stability. That word always sounds clean when someone else wants control. He continued, smooth and careful. "Mrs. Whitmore has long-standing familiarity with her son's affairs. She is prepared to step in to ensure nothing is lost during this difficult period." My mother-in-law nodded softly, hands folded in her lap like she was in church. The performance was flawless, grief wrapped in respectability, concern packaged as duty. The judge turned a page. "Ms. Brooks," he said again, "your objection. On what grounds?" Before I could answer, my mother-in-law spoke. Not loud, not angry, just enough to slip into the record. "I'm only trying to help," she said. "My son would never have wanted things handled this way." This way meaning by me. I didn't look at her. I kept my eyes on the judge. "My objection," I said, "is to the assumption that I'm unfit to participate in decisions about my own family." Her attorney smiled faintly, the kind of smile meant to calm a child. "With respect," he said, "no one is saying you're unfit as a mother. We're saying you're overwhelmed. This is complex. These things require experience. Experience like inheriting power and expecting it to stick." Behind him, my husband's cousin leaned forward, whispering something into the ear of the aunt beside her. They didn't bother hiding it. They'd already decided how this would go. The judge cleared his throat. "Mrs. Whitmore," he said again, "you're asking for full authority effective today?" "Yes, Your Honor," her attorney answered for her. "And you're asking me to grant that without a full hearing?" "This estate can't wait," he said. "There are accounts, properties, business interests. Delays create risk." Risk, another clean word. The judge looked at me again. "Ms. Brooks?" I sat up straighter. I placed my hands flat on the table so no one could accuse them of shaking. "They filed this as an emergency. It isn't. They created urgency to shut me out." My mother-in-law exhaled softly, like she was disappointed in me. "She's grieving," she said to the judge. "She doesn't understand how these processes work." There it was, the line meant to sound kind and land like a verdict. The judge's expression didn't change, but his patience thinned. "Ms. Brooks," he said again, "if you have a legal objection, I need to hear it." "I do," I said, "but it isn't mine alone." Her attorney stepped closer to the bench. "Your Honor," he said, "we object to delay. The petitioner is ready now. The respondent has been uncooperative. We believe she's being influenced." Influenced, another word they love to use when they can't say what they mean. The judge looked between us, weighing the room. He could feel it. Everyone could. The way the air leaned toward my mother-in-law, the way money and confidence fill space. "Ms. Brooks," he said again, "who are we waiting for?" I didn't hesitate. "My attorney," I said. A flicker crossed my mother-in-law's face, just once. Then she recovered. "This is unnecessary," she said. "There's no one else." I turned slightly, just enough to meet her eyes. "There is," I said. The judge sighed.
"This is probate court, not a stage. If this is a tactic—" "It isn't," I said. "I'm asking you to wait for the person who has the documents." Her attorney scoffed quietly. "Your Honor, I said wait," the judge snapped, sharper now. He leaned back in his chair. "Minutes, not hours." My mother-in-law's hands unclasped. For the first time, she looked irritated, not grieving, not concerned, annoyed. "Miss Brooks," she said, her voice low, controlled, "you're embarrassing yourself." I didn't answer. The room settled into a tense quiet. Papers rustled. Someone coughed. The clock on the wall ticked louder than it should have. Then the doors opened. Not gently, not dramatically, just the sound of wood and metal moving with purpose. Footsteps followed, measured, confident, coming straight down the aisle. Every head in the courtroom turned. I stayed seated. "I object," I said clearly, my voice cutting through the shift in the room, "because my attorney isn't here yet." The footsteps stopped behind me. The footsteps stopped directly behind me. I didn't turn. I didn't need to. I recognized the weight of them, the unhurried pace of someone who wasn't rushing to save anything, because nothing here was actually lost. "Apologies for the delay, Your Honor," a man's voice said. Calm, clear, not loud. "I'm counsel for the respondent." My mother-in-law turned slowly in her seat, the way people do when they expect to see chaos and instead find control. Her eyes swept over him, assessing. No showy suit, no dramatic briefcase, just a dark jacket, clean lines, and a file tucked under one arm like it belonged there. The judge adjusted his glasses. "You are?" "Counsel for Imani Brooks," he said. "I'm here now." He didn't look at my mother-in-law. He didn't look at her attorney. He walked straight to the table beside me and set his file down once. Not hard, not gentle. Final. "I object to proceeding on this petition as filed," he said immediately. My mother-in-law's attorney stood again, irritation flashing across his face. "Your Honor, we've already—" "Filed improperly," my attorney interrupted, still calm, "and prematurely." The judge raised a hand, signaling for silence. "Explain." My attorney nodded once. "This petition requests emergency authority based on alleged risk. There is no verified emergency, no sworn declaration of immediate harm, no evidence of asset dissipation. What there is, however, is defective service." He opened his file and slid a document forward, not dramatically, just enough for the clerk to retrieve it. "The respondent was not properly served within the statutory window," he continued. "Additionally, the petitioner lacks standing to seek control over assets not subject to probate jurisdiction." The judge's eyes narrowed slightly as he read. My mother-in-law's attorney cleared his throat. "Your Honor, with respect, the petitioner is the decedent's mother. That grants—" "Emotion, not authority," my attorney said evenly. A murmur rippled through the gallery. I felt it shift, just slightly, like the room was leaning back toward center. My mother-in-law straightened her posture, chin lifting. "I'm only trying to protect my grandchildren," her voice smooth but sharper now. Their mother is clearly overwhelmed. My attorney turned toward her for the first time. He didn't blare, he didn't challenge. He acknowledged her the way one acknowledges a claim that has already been disproven. "Ma'am," he said, "this court isn't here to reward concern. It's here to enforce law." The judge looked up. "Counsel," he said to my attorney, "you mentioned standing." "Yes, Your Honor." He flipped a page. "The petition assumes these assets are subject to probate. They are not. At least not in the way the petitioner represents." That got her attorney's attention. "What exactly are you implying?" he asked. "I'm stating," he replied, "that this petition is attempting to seize control over property the petitioner does not control, and never did." The judge leaned forward. "You're telling me this estate isn't fully before this court?" "I'm telling you," my attorney said, "that proceeding on this motion without reviewing the full record would be a mistake." My mother-in-law's lips pressed together. She glanced back at her family, then forward again, regrouping. "This is all very convenient," she said. "My son trusted me. I handled his affairs long before he married." There it was, the line meant to remind everyone who she believed came first. The judge didn't respond immediately. He turned back to my attorney. "Counsel," he said, "what record are we missing?" My attorney didn't answer right away. He reached into his file and removed a sealed envelope, plain, official, stamped. "This," he said, holding it just high enough for the judge to see, "was filed with the clerk last year and is part of the confidential record. It was not disclosed in the petitioner's motion." My mother-in-law's attorney stiffened. "Your Honor, we have no knowledge of—" "Which is exactly the problem," my attorney said. "This petition presents itself as urgent while emitting controlling instruments." The judge's jaw tightened. "What kind of instrument?" My attorney met his gaze. "One that directly addresses who does and does not have authority." My mother-in-law shifted in her seat. For the first time her composure cracked just enough to reveal irritation beneath the polish. "Am I suggesting that my own son cut me out?" The question wasn't for the court. It was for the room, for the audience she expected to side with her. My attorney didn't answer her. He turned back to the judge. "Your Honor," he said, "before you consider granting any authority today, you need to review what Mr. Whitmore executed." The judge glanced at the envelope, then at my mother-in-law's attorney. "Were you aware of this?" Her attorney hesitated, a fraction too long. "We received various documents," he said carefully. The judge's eyes sharpened. "That wasn't my question." Silence. My mother-in-law spoke quickly. "This is all a misunderstanding," she said. "Whatever papers exist, my son wasn't thinking clearly. He was ill. He was grieving his marriage." My attorney's voice didn't rise. It didn't need to. "Mr. Whitmore was thinking clearly enough to be specific," he said, "and careful enough to anticipate today." The judge leaned back in his chair, studying the envelope like it had weight beyond paper. "You're asking me to pause this proceeding," he said. "Yes," my attorney replied, "and to review the controlling document before any authority is transferred." The judge exhaled slowly. He looked at my mother-in-law, at her attorney, at me. Then he nodded once. "Very well," he said. "Counsel, approach." My attorney stepped forward and placed the envelope on the bench. He didn't open it, he didn't explain it, he simply said the words that changed the room. "Before you sign anything, Your Honor," he said, "you need to see what Mr. Whitmore filed to exclude the petitioner." The silence that followed wasn't empty. It was waiting. The judge didn't open the envelope right away. He turned it once in his hands, eyes scanning the seal, the filing stamp, the date. Not curiosity, recognition. The kind that comes when something serious finally lands in front of you and you realize the room has been lying by omission. "This was filed," he said slowly, "under seal." "Yes, Your Honor," my attorney replied, "at Mr. Whitmore's request." My mother-in-law leaned forward. "What is that?" she asked, her voice too sharp for the role she'd been playing. The attorney ignored her. He broke the seal carefully, like the paper mattered less than the consequences of what it held. Inside wasn't a thick stack, just a few pages. Clean, intentional. He read the first line silently, then his jaw tightened. He cleared his throat and looked up. This is a trust amendment and letter of instruction executed by Graham Whitmore, dated 14 months prior to his death. My mother-in-law laughed once, short and disbelieving. "That can't be right," she said. "He never told me about any amendment." The judge's eyes didn't leave the page. He wouldn't be required to. Her attorney stood halfway. "Your Honor, before this is entered—" "Sit," the judge said flatly. He continued reading. The courtroom felt smaller with every second. I could hear whispering behind me, my husband's cousins leaning together, a nervous shuffle, someone checking a phone like they were looking for an exit. "This amendment," the judge said, "supersedes prior designations. It confirms the primary beneficiaries as the decedent's spouse, Imani Brooks, and their minor children." My mother-in-law's hands clenched in her lap. "And," the judge continued, his voice sharpening, "it explicitly excludes Celeste Whitmore from any inheritance, distribution, or authority over trust or estate assets." The words landed heavy, not dramatic, not loud, final. For a moment no one spoke. Then my mother-in-law stood up so fast her chair scraped loudly against the floor. "That's impossible," she said. "I'm her mother." The judge looked at her over the rim of his glasses. "That does not override a valid instrument." She shook her head, lips pressed tight, eyes flashing. "He wouldn't do that. He was confused. He was sick. Someone got to him." The judge turned another page. "This letter," he said, "is attached as a statement of intent. It explains the exclusion." My heart thudded once hard. I'd read it before, but hearing it spoken in this room felt different, like watching a truth step into light. The judge didn't read the whole thing. He didn't need to. He summarized. "Mr. Whitmore states that the exclusion is intentional," he said. He cites a history of manipulation, emotional harm, and repeated attempts to interfere in his marriage and parenting. A murmur swept through the gallery. I felt it shift. People straightening, people glancing at my mother-in-law instead of me. "He also states," he said, his voice sharpening, "that he acted to protect his wife and children from future coercion." My mother-in-law's face changed. Not anger, not grief. Shock. For the first time since I'd known her, she looked exposed, like the mirror had turned without warning. "That's not how it happened," she said, her voice tighter now. "I raised him. I sacrificed for him." The judge's tone stayed even. He acknowledged that, and still made this decision. Her attorney found his voice again. "Your Honor, intent aside, we contest capacity." The judge didn't look at him. He read on. "This amendment includes a certification of capacity, executed in the presence of independent counsel and witnesses." My husband's aunt leaned to my mother-in-law, whispering urgently. A cousin shook his head slowly, like he was recalculating something. Allegiances don't vanish, they rearrange when money speaks clearly. My mother-in-law's gaze snapped to me. "You knew," she said. Not a question, an accusation. I met her eyes. "I knew he wanted us protected." The judge raised his hand. "Enough," he said. "This instrument is valid on its face." My mother-in-law laughed again, louder this time, brittle. "So that's it," she said. "She gets everything?" "No," the judge replied. "The trust is administered according to its terms." Her attorney whispered something urgently in her ear. I watched her listen, then wave him off.
"This isn't real," she said. "He was influenced. He wouldn't have written that on his own." The judge closed the file. "You may disagree with his decision," he said. "You may not rewrite it." Her family behind her shifted again. Someone cleared their throat. Someone else looked down at the floor. The jury had lost confidence in its verdict. My mother-in-law turned fully toward the bench now, abandoning the softness. "If this stands," she said, "then it means she did it." The room stilled. "She turned him against me," Celeste said, pointing at me. "She isolated him. She manipulated him when he was vulnerable." The word hung in the air, heavy and deliberate. The judge's expression changed. Not belief, attention. "That," he said slowly, "is a serious allegation." Celeste straightened, regaining her posture, her certainty. "Then I want it on the record," she said. "Elder abuse, undue influence." A ripple of sound moved through the courtroom. Whispers, sharp inhales. A few heads turned toward me like they were seeing me for the first time. My attorney didn't move. He didn't object. Not yet. The judge leaned forward. "Mrs. Whitmore," he said, "you understand what you're alleging." "Yes," she said, her voice steady now, "and I won't be silenced." The judge nodded once. "Then this court will pause," he said, "because accusations like that require evidence." He looked at her carefully, "and we are not moving forward another inch without it." The room froze. Not because she'd won, because she'd just crossed a line she couldn't step back from. The word didn't echo. It didn't need to. Elder abuse. Celeste said it like she was placing a final card on the table, slow, deliberate, certain it would change everything. She didn't look at me when she said it. She looked at the judge, like she was doing him a favor by naming what she'd decided was true. "She isolated my son," Celeste continued. "She controlled who could see him. She controlled his finances. And when he was weak, she took advantage." Her attorney stood beside her now, alert, ready to turn accusation into procedure. "Your Honor," he said, "these are serious concerns. We're requesting immediate inquiry and protective intervention." I stayed still. I'd learned that stillness unsettles people who expect reaction. Celeste turned toward me then, eye sharp. "You know what you did," she said. "You made him dependent. You kept us away." The judge didn't respond immediately. He watched her carefully, measuring not just the words but the timing. "Mrs. Whitmore," he said, "elder abuse is a grave allegation. What evidence do you have today?" Today, not someday, not after fishing, now. Celeste lifted her chin. "Witnesses." She gestured behind her. Two people stood awkwardly near the back row, a distant aunt I'd met twice, a family friend who'd always called me sweetheart in a tone that wasn't kind. They looked nervous, eyes darting, hands clasped like they were waiting to be told where to stand. They saw how she behaved, how angry she became, how unstable. Unstable. The word slid out smooth. "She yelled," the aunt said quickly, stepping forward before anyone asked her to. "She was always upset, defensive." Defensive, another clean word. The family friend nodded. "Graham didn't seem like himself," she added. "He changed, he stopped calling." I felt the eyes in the room shift again, not fully, just enough. Celeste seized it. "You see," she said, "she took advantage of his vulnerability. She pressured him. She rushed him into legal decisions he didn't understand." The judge leaned back slightly, hands folded. "Counsel," he said to Celeste's attorney, "do you have medical reports?" The attorney hesitated. "Not at this time." "Police reports?" "No, Your Honor." "Adult Protective Services involvement?" "No." The judge's eyes narrowed. "Financial records showing misuse?" "We are requesting discovery," the attorney said quickly. "These things are often hidden." The judge shook his head once. "Discovery is not a substitute for evidence. You don't accuse someone of abuse to see what turns up." Celeste's voice rose, frustration bleeding through the polish. "He was scared," she said. "He didn't want to upset her." The judge looked at her directly. "Then explain why he met with counsel alone, why he executed documents with independent witnesses, and why he provided a capacity certification." Celeste opened her mouth, then closed it. Her attorney stepped in.
Your Honor, he said, patterns of coercion aren't always documented. Victims don't always report. That's true, the judge replied, which is why I asked what you have today. Silence. Then Celeste changed tactics. She's aggressive, she said, pointing at me. She has a temper. Everyone knows that. I felt it then, the familiar tightening, the way certain words are chosen carefully, like tools. Aggressive, angry, unstable, never grieving, never scared, never human. My attorney finally spoke. Your Honor, he said, calmly, may I respond? The judge nodded. These allegations rely entirely on character assassination. No dates, no documents, no contemporaneous complaints, just opinions offered after the money was cut off. Celeste scoffed. That's not fair. It's accurate, he replied, and it's not enough. The judge turned back to Celeste. Mrs. Whitmore, he said, elder abuse is a grave allegation. What evidence do you have today? Celeste's face flushed. He didn't want to embarrass the family, she said. He was protecting her. The judge's voice hardened. That is speculation. Celeste's attorney tried once more. Your Honor, at minimum we request the court freeze assets pending investigation. The judge shook his head. You haven't met the threshold. Celeste's hands clenched.
Her eyes darted to her witnesses, then back to the bench. She was losing control of the room, and she knew it. This isn't over, she said. I won't let her get away with this. My attorney didn't look at her. He reached into his file and pulled out a second envelope, plain, thinner than the first, marked. Your Honor, he said, we anticipated this. The judge's attention sharpened. Anticipated what? The allegation, my attorney replied, and the need for proof. He held the envelope out. We have Graham Whitmore's sworn statement, he said, and a documented timeline. The room went quiet again, not the uneasy silence from before, the kind that knows something is about to land. My attorney didn't rush. He opened the second envelope the way people do when they already know what's inside and aren't afraid of it. He removed a single document first, then another, stacking them neatly on the table before handing the top page to the clerk. This is a sworn statement, he said, executed by Graham Whitmore 8 months before his death. The judge took it, read the heading, then stopped. Not because it was confusing, because it was precise. I watched his eyes move down the page, slower now, careful. The room held its breath without realizing it. He anticipated this, the judge said quietly. Yes, Your Honor, my attorney replied. He wrote it specifically in the event his mother accused his wife of coercion or fraud. Celeste laughed, sharp and short. That proves nothing. The judge didn't look up. I wasn't speaking to you. He continued reading. Then he looked up at me, not with sympathy, but with understanding. This statement explains that Mr. Whitmore requested private counsel, the judge said. He states he met alone, without his wife present. He affirms he was of sound mind and acting voluntarily. My attorney slid another page forward. Attached is the attorney's certification of capacity, he said, along with witness affidavits. Celeste's attorney stiffened. He leaned closer to her, whispering urgently. She waved him off again, jaw tight. The judge flipped to the next page. Independent witnesses, he said. No family members. The words fell like weights. My attorney spoke again. Mr. Whitmore also documented the pressure he was experiencing. He nodded toward the clerk, who handed the judge a small stack of printed pages. These are messages, my attorney said. Texts and emails from the petitioner. Celeste straightened. That's taken out of context. The judge read anyway. He didn't read them all. He didn't need to. His face changed with each line. Why haven't you signed yet? This is taking too long. You're embarrassing the family. I'll come by with someone who can notarize. The judge looked up sharply. You attempted to bring a notary to his home. Celeste's mouth opened, then closed. Her attorney spoke quickly. Your Honor, families often assist. Sit, the judge snapped. My attorney didn't gloat. He just continued. There are also voicemails, he said, left after Mr. Whitmore asked for space. The judge exhaled slowly. I've seen enough, he said. The pattern is clear. Celeste leaned forward, voice rising. He was confused. He didn't know what he was doing. The judge's patience finally broke. He knew enough to document coercion, he said. He knew enough to anticipate this courtroom. Celeste's attorney's face had gone pale. He stared at the table like it might offer an escape. The judge turned back to my attorney. Counsel, he said, why was this not disclosed in the petitioner's motion? My attorney didn't hesitate. Because it undermines their claim. Silence followed. Heavy. Final. The judge set the papers down. This court will not entertain allegations built on hindsight and resentment, especially when the record shows deliberate planning by the decedent. Celeste's shoulders sagged for just a second, then she caught herself, lifting her chin again. This doesn't prove she didn't manipulate him, she said weakly. The judge looked at her. It proves the opposite. My attorney nodded once. There's one more thing, he said. The judge's eyes lifted. Go on. My attorney reached into his file again. Earlier today, he said, before this hearing, there was an attempted access to one of Mr. Whitmore's financial accounts. Celeste froze. It triggered an alert, an attempted login and transfer request. The judge leaned forward. By whom? My attorney didn't look at Celeste. He didn't need to. The account provider traced the attempt, he said. It originated from the device associated with the petitioner. The room went completely still. The judge's voice was low now. Mrs. Whitmore, he said, is that true? Celeste didn't answer. Her attorney stared straight ahead, jaw clenched, knowing exactly where the landmine had been buried and that they'd stepped on it anyway. Silence. The silence didn't break all at once. It cracked. The judge sat back in his chair, fingers steepled, eyes fixed on Celeste like she'd finally shown him who she was beneath the performance. He didn't raise his voice. He didn't need to. The petition for emergency authority is denied. The words were plain. Final. No ceremony. Celeste's attorney opened his mouth, then closed it. Whatever argument he'd been holding on to had collapsed under the weight of the record. The judge continued. This court is not entertaining control of any assets today, not to the petitioner, not to anyone. Celeste's hands tightened around the edge of the table. Your Honor. Enough, the judge said. You made serious allegations in this courtroom. You did so without evidence.
And you did so after being in possession of documents that should have stopped this filing altogether. Her attorney stiffened. We dispute that characterization. You may dispute it at the appropriate time, the judge replied, which will be soon. He turned to the clerk. Set an order to show cause hearing, he said, to address potential sanctions for bad faith filing and false assertions made to this court. The word sanctions hung in the air. Celeste's composure faltered, just briefly. Her eyes darted toward her attorney, then back to the judge. This is unnecessary, she said. I was trying to protect my family. The judge didn't soften. Intent does not excuse conduct, he said, especially when that conduct attempts to bypass lawful instruments. He glanced down at his notes, then back up. Given the attempted account access and the coordinated nature of this filing, I am issuing protective orders effective immediately. My stomach tightened, not from fear, from relief. Mrs. Whitmore, the judge said, you and any parties acting on your behalf are prohibited from contacting financial institutions, trustees, employers, schools, or any third parties associated with the estate or the minor children. Celeste's head snapped up. You can't. I can, the judge said calmly, and I am. Her mask cracked then, not fully, but enough for the room to see the anger beneath the polish. This is outrageous, she said. She's turning everyone against me. The judge's gaze stayed steady. No, he said. The record is. He turned to my attorney. Counsel, he said, draft the order. I will sign it today. My attorney nodded once. Thank you, Your Honor. Celeste's family behind her shifted uncomfortably. The aunt who'd spoken earlier looked at the floor. The cousin leaned back, arms crossed, no longer eager to be seen. The judge addressed the room. "Let me be clear," he said. "This court does not reward urgency manufactured through intimidation, nor will it tolerate accusations used as leverage." He looked directly at Celeste. "If you wish to pursue allegations of abuse, you will do so with evidence, through proper channels, and without attempting to seize assets in the meantime." Celeste's lips trembled, not with grief but with fury. Her attorney leaned in, whispering urgently now. She shook him off. "This isn't over," she said, voice sharp. "You're making a mistake." The judge didn't respond. He'd already moved on. "Court is in recess," he said. The gavel struck. People began to stand. Papers shuffled. The room exhaled like it had been holding its breath too long. I gathered my things slowly, no rush, no victory lap. I wasn't here to perform relief. As I stepped into the aisle, Celeste leaned toward me, close enough that only I could hear. "You think you've won. You have no idea what you've started." I met her eyes. I didn't raise my voice. I didn't smile. "This was never a game," I said. She recoiled like I'd struck her. My attorney touched my elbow lightly. "Let's go," he murmured. We moved toward the side exit, the courthouse noise swelling around us. Conversations buzzed. Someone laughed nervously. Someone else argued in hushed tones. As we reached the doors, my attorney's phone vibrated. Once, then again. He stopped walking. "What is it?" I asked. He glanced at the screen, his expression tightening just slightly. "That didn't take long," he said. The notification glowed between us. "Security alert. Attempted access blocked." The hearing was over. Someone was still trying. We didn't stop in the hallway. My attorney guided me straight through the side doors and out onto the courthouse steps, where the air felt sharper, cleaner, like the building itself wanted distance from what had just happened inside. The sun was high. People passed without looking at us. Life moves on. It always does. My attorney held his phone in his hand, eyes fixed on the screen, not panicked, focused. "That alert wasn't delayed," he said. "It happened minutes ago." "Before recess?" I asked. He nodded, while the judge was still speaking. That detail landed hard. She hadn't waited. She hadn't reflected. She'd moved. We stopped near the curb. He unlocked his phone and tapped once, then again. He dialed. It rang twice. "Howarthon Trust Services," a woman answered, her voice calm and professional. "This call may be recorded. How may I assist?" "This is counsel for Imani Brooks," my attorney said. "We just received a security alert regarding an attempted access to Mr. Whitmore's accounts. I need confirmation and details." There was a brief pause, the sound of keys, not frantic, procedural. "Yes, I see the alert. One moment while I verify authorization." My attorney gave my name. I confirmed. The woman's tone sharpened, not with alarm, but with precision. "Confirmed. An attempted login occurred through the beneficiary portal. Multi-factor authentication failed. Immediately after, there was an attempted change to the primary contact phone number." My throat tightened. "Change to whose?" I asked. The woman didn't answer me directly. "Counsel," she said, "are you authorizing disclosure to your client?" "Yes," my attorney answered instantly. The attempted phone number update was submitted from a device associated with Celeste Whitmore or an individual acting on her behalf. The street noise faded. Cars passed. Someone laughed across the way. None of it felt real. "Was access granted?" my attorney asked. "No," she replied. "The account is blocked. The account is flagged." "Any other attempts?" he asked. "Yes," she said. "A call was placed to our service line approximately 4 minutes later. The caller attempted to obtain balance information and initiate a transfer." My chest went cold. "And?" my attorney pressed. "The caller failed identity verification," the woman said. "The call was terminated and logged." I closed my eyes for half a second. I could picture it, Celeste turning her phone face down in the courtroom, not to hide emotion, but to hide action, moving while everyone else was still standing. "Given today's court order," my attorney said, "what steps have you taken?" "Immediate escalation," the woman replied. "All accounts are now restricted. No changes permitted without in-person verification and counsel authorization."
Good, he said. Freeze everything. Already done, she said. Additionally, due to the attempted interference, the trust's protective provisions have been triggered. My attorney went still. Say that again, he said. The protective clause, she repeated. The no interference provision tied to beneficiary conduct. I felt my pulse climb. What does that mean? I asked. The woman's voice stayed even. It means the trustee has initiated a review for forfeiture. For a moment, I couldn't breathe. Forfeiture, my attorney repeated slowly. Yes, she said. The trust language is explicit. Any attempt by an excluded or contingent party to access, redirect, or interfere with trust assets triggers automatic review and suspension of any potential distribution. I stared at the courthouse doors behind us. Somewhere inside, Celeste was probably still rehearsing what she'd say next, planning her next angle. She did this to herself, my attorney said quietly. There's more, the woman continued. A formal report has been generated, time-stamped, IP logged, device associated. My attorney exhaled slowly. Send it to my office and note there is an active protective order issued today. Already noted, she replied. The trustee will file a declaration with the court. The call ended. The quiet afterward felt unreal, like the world had paused to let the consequences settle. She tried again, I said. It wasn't a question. Yes, my attorney replied. And she didn't just try, she created evidence. What happens now? I asked. He met my eyes. Now it becomes irreversible. I swallowed. She can't undo it? No, he said. That clause exists for exactly this reason, to stop people who think urgency gives them permission. I leaned against the stone railing, grounding myself. I didn't feel victorious. I felt steady, like something heavy had finally locked into place. My attorney's phone buzzed again, a new message. He glanced at it, then turned the screen toward me. Trust status update. Forfeiture review initiated. Distributions suspended. She thought the court was the obstacle, he said. It wasn't. I looked back at the courthouse one last time. The doors were still closed, quiet, impassive. This wasn't about winning anymore. This was about finality. The follow-up hearing was scheduled fast. Not weeks, not months. 3 days later. That alone told me everything. When we walked back into the same courtroom, the energy had changed. The room wasn't leaning toward Celeste anymore. It wasn't waiting for her performance. It was braced for consequences. She arrived late this time. No cream coat, no soft colors. A darker suit, sharper lines, like she'd finally accepted that grief wasn't going to protect her here. The family rows behind her were thinner now. One cousin, no aunt. The friend who'd spoken last time was gone. Allegiances don't disappear quietly, they just stop showing up. The judge entered without ceremony. He didn't greet anyone. He sat, opened the file, and went straight to the point. This is the court's order to show cause hearing, he said. We are here to address the prior emergency petition, subsequent allegations, and post-hearing conduct. Celeste's attorney stood, slowly, carefully. The confidence he'd walked in with the first time was gone. Your Honor, he said, before we proceed, my client wishes to withdraw all contested claims. The room murmured. The judge didn't look impressed. You already withdrew the petition. We are past that. The attorney swallowed. Then we offer an apology to the court for any confusion created by the filing. Confusion? The judge finally looked up. His eyes were sharp now, focused. This court does not confuse intent with outcome, and it does not confuse mistakes with strategy. He turned a page. Let's talk about what actually happened. He began listing facts the way judges do when they're done entertaining stories. An emergency petition was filed without proper service. It omitted controlling instruments. It alleged instability without evidence. It attempted to seize authority not held by the petitioner. Celeste shifted in her seat. After the court recessed, there was an attempted access to protected financial accounts. The judge continued. Her attorney stiffened. This attempt was blocked by institutional security. It was logged, time-stamped, device associated. He looked directly at Celeste. Celeste's face drained of color. The judge turned to my attorney.
"Counsel," he said, "the logs?" My attorney stood and handed them over, clean, labeled, boring in the way evidence always is when it's fatal. The judge read silently for a long moment. IP address, device match, call attempt, failed authentication. He looked back up. This wasn't accidental. Celeste's attorney rose again, voice subdued now. "Your Honor, my client acknowledges the attempt and regrets—" "No," the judge said sharply, "you will not minimize it." The attorney stopped mid-sentence. "This court issued a clear order, and your client tested it immediately." Celeste opened her mouth. "I was trying to—" "Stop," the judge said. "Every time you speak, it makes it worse." The room went still. He turned another page.
"The trustee has filed a declaration," he said. "It confirms that the protective clause within the trust has been triggered due to attempted interference." Celeste's breath caught, audibly. "The court recognizes the trust structure as controlling," the judge continued. "This court further recognizes the decedent's clear intent as expressed in the amendment and accompanying statement." He looked up. "That intent excludes the petitioner." The words didn't echo. They didn't need to. Celeste's attorney sat down, slowly, defeated. "I am entering an order today," the judge said, "affirming the validity of the will and trust, denying all claims brought by the petitioner, and recognizing the trustee's authority to administer without interference." He paused. "I am also imposing sanctions." Celeste's hands began to shake. She tried to steady them on the table. "Sanctions for bad faith filing," the judge said. "Sanctions for false allegations made in open court, and sanctions for violating a protective order." The attorney nodded once. There was nothing left to say. Celeste looked around the room, searching for support. She found none. The cousin stared straight ahead. The gallery avoided her eyes. She stood suddenly. "This is unbelievable," she said. "I lost my son." The judge didn't soften. "You did not lose him here," he said. She pressed on, voice cracking now. "I'm being erased." The judge leaned forward, his voice firm, controlled, final. "No," he said, "you attempted to erase his choices." He gestured toward the file. "This court does not exist to rehabilitate reputations or reward persistence. It exists to enforce the record." Celeste's mask collapsed then, not into tears, into something harder, rage stripped of power. "You're letting her take everything," she said, pointing at me. The judge didn't look at me when he answered. "She is not taking anything," he said. "She is receiving what was left to her." He stood, signaling the end. Then he said the line that froze the room completely. "Mrs. Whitmore," he said, his voice low and deliberate, "you didn't lose your son today. You lost the right to rewrite him." No one moved. No one breathed. And for the first time since this began, Celeste had nothing left to say. The end didn't arrive with applause. It arrived in emails, signatures, confirmations, and silence. Within a week of the sanctions order, the trustee took over everything exactly as the documents required. No conversations, no negotiations, no appeals to emotion, just execution. Accounts were retitled. Access was rerouted. Statements arrived with my name on them, not as a favor, not as a concession, but as a matter of record. The house was secured first, locks changed, alarm codes updated, a notice placed on file with the security company, no access granted to extended family without written authorization from counsel. The title remained outside probate, exactly where Graham had placed it. Untouchable. Quiet. I didn't celebrate. I walked through the room slowly, touching the walls, grounding myself in what stability actually feels like. Not luxury, not victory. Safety. The kids noticed before I said anything, not because I explained it to them, but because the air changed. Mornings became predictable again.
No unexpected cars slowing near the curb. No unfamiliar numbers lighting up my phone. The tension that had lived in my shoulders finally loosened its grip. At their schools, the boundaries were formalized. Letters delivered, copies filed. A simple directive entered into the system. No information released, no pickups authorized, no visits without written clearance. The administration didn't ask questions. They didn't need the story. The record spoke. That was the pattern now. The record spoke. I didn't have to. The trustees sent updates weekly. Clean language, neutral tone. Funds distributed according to schedule. Accounts balanced. Receipts attached. Every line item traceable. Nothing hidden. Nothing rushed. It was boring in the best way possible. Celeste didn't call. She couldn't. The protective order made sure that. But even without it, there was nothing left for her to say. Performance requires an audience. The record doesn't watch. Once a letter arrived addressed to the family. No return address. My attorney handled it. It never crossed my threshold. That boundary stayed intact because it was enforced early, firmly, and without apology. One evening, after homework was done and dinner plates were stacked in the sink, my youngest climbed onto the couch beside me. He leaned into my side, heavy and warm, the way children do when they finally feel safe enough to rest their weight. "Are we okay now?" he asked. "Yes," I said. I didn't hesitate. I didn't qualify it. "We are." He nodded, satisfied, and turned his attention back to the television. That was all he needed. Children do not require explanations. They require consistency. Later that night, after they were asleep, I opened the folder Graham had prepared, not because I needed reassurance, but because I wanted to remember the difference between chaos and clarity. Every document was dated, every signature witnessed, every choice explained plainly, without bitterness. He hadn't written to punish anyone. He'd written to protect what mattered. That distinction stayed with me. People assume closure looks like forgiveness or reconciliation. It doesn't. Closure looks like doors that don't reopen, numbers that don't change, systems that don't bend when pressed. Weeks passed. The first formal distribution arrived. Not dramatic, just a notification and a deposit that matched exactly what the trust outlined. No more, no less. The house remained secured. The accounts remained frozen to anyone who thought urgency could override consent. Celeste didn't show up at the gate. She didn't send intermediaries. She didn't escalate. She disappeared. And that, more than anything, confirmed the truth. This was never about grief. It was about control.
When control failed, so did the performance. On a quiet Saturday morning, I sat at the kitchen table with my coffee cooling beside me and sunlight stretching across the floor. The kids were laughing in the next room, arguing about something that wouldn't matter by lunchtime. Life had returned to its proper scale. I thought about the courtroom, the accusations, the certainty with which Celeste had spoken. How confident she'd been that blood entitled her to ownership. She wasn't wrong about one thing. She believed in inheritance. She just misunderstood what it meant. Inheritance isn't about who came first. It's about who stayed true, who protected, who planned when no one was watching. When people try to erase you with a story, they expect you to fight back with a louder one. That's how they win. Noise against noise. Emotion against emotion. But proof doesn't argue. Proof waits. She thought blood gave her rights. The record proved love did. Thank you for staying with me through this story. If you've ever faced betrayal, manipulation, or someone trying to rewrite your truth, I'd love to hear your thoughts or your experience in the comments. Your voice matters here. If this story resonated with you, please click the like button. It really helps the channel reach others who need these stories. And don't forget to subscribe and turn on notifications so you're here for the next one. I appreciate you more than you know.